Have you ever stopped to think, what really stands between you and potentially bad financial advice? Or maybe what it takes to become one of those trusted financial guides here in South Africa?
It's a really important question.
Welcome to the Deep Dive. Today, we're peeling back the layers on a real cornerstone of South African financial law. The Financial Advisory and Intermediary Services Act 37 of 2002. Most people just call it the FAIS Act.
That's the one, and it's fundamental.
So our mission today is basically to break down this pretty hefty act. We want to make it clear, maybe even engaging, whether you're just trying to manage your own investments, thinking about retirement, or maybe you're deep in law school textbooks.
Absolutely. It affects a lot of people.
We'll look at its purpose, the key rules, and really what it means for you day to day. And joining us to connect all the dots is our resident expert.
Glad to be here. Look, it's a really pivotal piece of legislation, and it gets updated quite often. The version we're looking at incorporates changes right up to April 2023.
So it stays relevant.
Exactly. And at its heart, FAIs is all about clarifying how your financial dealings are protected, ensuring there's a baseline of trust. It was signed back in November 2002, and it fundamentally aimed to regulate who can give financial advice and intermediary services, and crucially, how they have to do it.
Okay, so let's get right into that. What was Parliament really trying to achieve with FAIS? It can't just be a load of red tape, right?
Not at all. It was a significant shift.
The Act itself says it's to regulate the rendering of certain financial advisory and intermediary services. But I guess for you, the listener, the real point is simpler. Like, think about the trust you place in someone advising on your life savings or insurance.
Precisely. This act is the legal framework trying to make sure that trust isn't misplaced, that you're protected.
Right.
And what's fascinating, I think, is how FAIS really transformed the financial services scene. Before it, things were, let's just say murkier.
A bit Wild West.
Yeah. You could say that. This act drew a very clear line. It separates legitimate, regulated service from, anything else. It's about building confidence through fairness, competence, and transparency in what can be a really complex area. It basically professionalized the whole sector.
Okay, that makes sense. So to really grasp how FAIS protects you, we need to get clear on some key terms first. Who and what falls under its scope? Like, who counts as a financial services provider?
Right. Definitions are key here. So at its simplest, a financial services provider, or FSP, is generally anyone, a person or a company who, as a regular part of their business, gives financial advice or helps arrange financial products for clients, or does both.
But not everyone who works at the company.
Exactly. That's an important distinction. It specifically excludes people who just work for that provider in certain roles.
So that brings us to the representative, doesn't it?
Spot on. A representative is someone working for that licensed FSP, giving advice or providing services on their behalf, kind of under their umbrella. But importantly, it's not just any employee. It excludes purely clerical or admin staff who aren't making judgments or recommendations about financial products.
So it's about who actually influences your decisions.
Precisely. It's about that direct interaction. And then there's the term client. This isn't just, the general public out there. It refers to a specific person or maybe a group who receives or might receive a financial service directly.
Why is that specific focus important?
Because it means the provider owes their duties directly to you, the individual client. It personalizes the responsibility.
Got it. So we have the people involved. What about the things they're advising on or arranging? What counts as a financial product in the FAIS world? Is it just shares and bonds?
Oh, it's much broader than that, and deliberately so. When FAIS talks about a financial product, it covers a huge range. Yes, shares, but also things like your retirement annuity, unit trusts, life insurance policies, short-term insurance like car or home, even your medical aid scheme benefits.
Medical aid too. Wow.
Yes, and foreign currency investments, certain types of bank deposits. The list is quite extensive. The idea was to cover nearly every significant way people interact with financial services and investments.
So designed to be comprehensive.
Absolutely. And importantly, the authority that's the body overseeing AIS, the Financial Sector Conduct Authority, they actually have the power to declare new things as financial products if the market evolves, so the act can adapt over time.
That makes sense. Keeps it from becoming outdated. Are there things that are specifically not financial products under FAIS?
Yes, good point. The act does exclude certain things, mainly products that are already very heavily regulated under a different specific law. This is just to avoid regulatory overlap and confusion. Streamlines things a bit.
Okay. And the word advice itself, that seems like a really crucial one to define. What's the difference between, say, me telling a friend I like a certain share, and regulated financial advice.
That distinction is absolutely vital. Under FAIS, advice isn't just any comment about finance. It has to be a personalized recommendation, guidance, or a proposal specifically related to buying, selling, investing in, or changing a particular financial product for you.
So it's got to be tailored.
Exactly. Think of it as, based on your situation, I recommend you invest in Fund X. What it isn't is just providing general factual information, like explaining how a type of investment works generally, or what the historical performance of a market index was, or simply describing the steps to complete a transaction.
So just facts aren't advice.
Correct. Even doing an analysis or comparison, if it doesn't come with an explicit recommendation to you, might not count as advice under the Act. Also, advice given by the Board of Trustees of a pension fund to its members about their benefits usually falls outside this definition, too. It's really about that specific, personalized recommendation.
Okay, that clarifies advice. What about intermediary service? Is that just selling?
It's broader than just selling, although selling can be part of it. An intermediary service is basically any action other than giving advice that someone performs for you or for a product supplier that results in you entering into a transaction for a financial product.
Like handling the paperwork.
Yes, or managing the product, administering it, collecting premiums or contributions. It's about facilitating the transaction and the ongoing management of the product. Again, there are some exclusions to prevent overlap, like a bank just acting as a payment channel wouldn't necessarily be providing an intermediary service in that context. It focuses on those actively involved in the transaction process.
You know, digging into these definitions really highlights how crucial they are. It's not just legal jargon. It actually determines who's responsible for what, right?
Absolutely. It sets the boundaries of the regulation.
So once we understand who and what is covered, the next big question is, what do they actually have to do to be allowed to operate? This brings us to those fit and proper standards we hear about. What are they, and why are they so important for protecting us?
Right. This is really where FAIS starts to bite in terms of professional standards. You can't just hang up a sign and start giving financial advice. As of a date set way back, you need a license to act as a financial services provider, or you need to be properly appointed as a representative of a licensed provider.
And getting that license isn't easy.
No, it involves meeting these fit and proper requirements. The authority sets out very detailed standards. And these aren't just vague guidelines, they're formal regulatory instruments. They cover different categories: the providers themselves, their key managers, the representatives dealing with clients, even the compliance officers.
What sort of things do they cover? Is it just qualifications?
Qualifications are part of it, yes, competence, which includes experience and passing relevant exams. But it's much more. It covers personal character. Things like honesty and integrity are absolutely central. It looks at their operational ability. Can they actually run the business properly? And their financial soundness. Are they stable?
So it's a pretty thorough check.
Very thorough. And crucially, it's not a one-time thing. There's a strong emphasis on continuous professional development, or CPD. The financial world changes fast, so advisors need to keep their knowledge up to date.
So getting the license is just the start.
Exactly. Providers, their key people, their representative, they all have to continue to meet these fit and proper standards after they're authorized, including doing their CPD. To even get the license in the first place, applicants have to convince the authority they meet all these requirements. And the authority can put conditions or restrictions on a license, depending on what services they offer or their specific setup.
And if they don't keep up, what are the consequences?
The consequences can be serious. If a provider or representative fails to meet or maintain these standards, their license can be suspended or even withdrawn completely by the authority. This can also happen if they weren't fully truthful during the application process or gave misleading information. It's a robust system designed to maintain high standards.
Okay, so the fit and proper rules are like the gatekeepers, making sure the right people are in the industry. But once they're in, how does FAIS ensure they actually, behave properly towards clients day to day?
That's where the codes of conduct come into play. This is another critical part of FAIS.
The rulebook for behavior.
Sort of, yes. The authority, after consulting with the industry and consumer groups, drafts and publishes these codes of conduct. And once published, they become legally binding. They can even create different codes for different types of providers or clients to make sure the rules are relevant.
What's the main goal of these codes?
Primarily, they're designed to ensure that you, the client, can make informed decisions and that your needs are appropriately met. They lay down core principles. Providers and reps must act honestly, fairly, with due skill, care, and diligence. And critically, they must always act in the client's best interests and uphold the integrity of the financial services industry.
Acting in the client's best interest sounds key.
It is fundamental. The codes also mandate practical things like gathering sufficient and appropriate information about your financial situation before giving advice. They have to manage conflicts of interest fairly and, importantly, tell you about any potential conflicts. And, of course, comply with all the relevant laws.
Does it get into specifics like record keeping or marketing?
Absolutely. The codes cover crucial operational details. Things like requirements for proper disclosure of all material information, keeping adequate records of advice and transactions usually for at least 5 years. They strictly prohibit misleading or fraudulent marketing practices. They also cover the proper safeguarding of any client funds or important documents they might hold. And many codes require providers to have professional indemnity insurance or fidelity cover.
So, like insurance in case they make a mistake.
Exactly. It adds another layer of protection for the client if something goes wrong due to negligence or fraud. It's all part of building that trustworthy environment. Providers also have duties regarding compliance officers, record keeping, including complaints, and proper accounting and audits, especially for client money.
It sounds really comprehensive, covering ethics and practicalities. But, even with the best rules and intentions, disputes can still happen. Things can go wrong. That's where the ombudsman comes in, right? Tell us about that. How does that system work for a client who has a problem?
Yes, the Ombud for financial services providers, often called the AI Ombud, is a really vital part of the system. The Act specifically established this office. Its main job is to consider and sort out complaints from clients against financial services providers.
How does it work? Is it like going to court?
No, importantly, it's designed to be different. The goal is to be procedurally fair, yes, but also informal, economical, and quick. It focuses on finding a resolution that's equitable, what's fair in the specific circumstances, rather than strictly applying complex legal precedent like a court might. And crucially, the Ombuds's office is independent and impartial.
That sounds much more accessible for the average person. Does the Ombud handle every single complaint? Are there limits?
That's a key point. There are some practical limits. For instance, the Ombud generally won't look into something that happened more than 3 years before you lodge the complaint. Also, if you've already started court proceedings about the same issue, the Ombud usually won't take the case.
Okay, so you can't try both at the same time?
Generally, no. And the Ombud can also decide not to investigate if they feel the issue would be better handled by a court or perhaps another dispute resolution forum. It's about using the right tool for the job and ensuring the Ombud focuses where it can be most effective.
So if your complaint is accepted, what happens then?
Well, the Ombud's first step is usually to try and see if a settlement can be reached through conciliation, basically, helping you and the provider come to an agreement.
And if that doesn't work?
If conciliation isn't possible or doesn't succeed, the Ombud will then investigate fully and make a formal determination. This determination can go several ways. They might dismiss the complaint if it's not upheld, or they could uphold it either fully or partly.
What can they order the provider to do?
They have significant power here. They can order the provider to pay fair compensation for any financial loss or damage you suffered. They can direct the provider to take specific steps to fix the problem. Essentially, they can make orders similar to what a court might make in that situation. And these determinations are legally binding. They have the status of a civil judgment.
Wow, so they have real teeth.
They certainly do. And the office itself is funded properly under the Financial Sector Regulation Act and is accountable, audited by the Auditor General, ensuring its own integrity. It's a crucial safety net for consumers.
Okay, so we have the rules for getting in the fit and proper standards. We have the rules for behavior, the codes of conduct, and we have the Ombud for individual complaints. But what about overall enforcement? How does the authority, the regulator, keep the whole system in line? What powers do they have?
The authority, the FSCA, has quite a range of enforcement powers to ensure compliance across the board. They can, for example, direct providers, reps, or even compliance officers to provide specific information or documents.
So they can demand answers.
Yes. They can also tackle misleading advertising directly, instructing someone to stop publishing an ad or to change it if it's confusing or deceptive about financial services. If they suspect a provider is breaking the rules, they can demand meetings or even go to court to get an order restraining the business or protecting client funds if there's a serious risk.
And what about taking away a license? We touched on that with fit and proper. Are there other reasons a license can be suspended or withdrawn?
Absolutely. Beyond failing the fit and proper test, a license can be suspended or withdrawn for several other reasons. Things like not disclosing important information during the application or giving false information later, simply not complying with the FAIS Act itself, or related standards under the broader Financial Sector Regulation Act, even failing to pay required levies or penalties, or not sticking to conditions imposed on their license.
Is it an immediate process?
There's a proper procedure involved. The provider normally gets a chance to respond to the allegations. However, in urgent situations where there's a real risk of substantial harm to clients or the public, the authority can issue a provisional suspension more quickly while they investigate further.
And if someone's license is withdrawn, can they just start again?
Not necessarily. Someone who is debarred, which often happens alongside license withdrawal, can be prohibited from applying for a new license for a specified period. Also, licenses can naturally lapse under certain circumstances, like if an individual provider becomes permanently incapacitated or passes away, or if a company is liquidated or just becomes dormant. Providers can also voluntarily surrender their license.
What about the representatives working for the provider? Can they be kicked out?
Yes, that's covered by debarment too. A licensed financial services provider actually has a duty. They must debar a representative or even one of their key managers if they find out that person no longer meets the fit and proper requirements or has seriously broken the rules of the act.
So the provider has to police its own people.
To a large extent, yes. But that debarment process itself has to be lawful, reasonable, and procedurally fair. The representative has to be notified and given a chance to respond. And the authority keeps a central public register of everyone who has been debarred, which is crucial for preventing them from just popping up somewhere else.
That transparency is important. Any other enforcement tools?
A couple more significant ones. The authority can declare specific business practices undesirable if they think they harm client relationships, unfairly prejudice clients, or are deceptive. Once a practice is declared undesirable, providers are prohibited from engaging in it and might be ordered to fix any harm done.
And actual criminal charges.
Yes, the Act defines several serious offenses. Operating without a license when you need one is a major one. Making false or misleading statements in applications or reports, or lying to an auditor or compliance officer, these can lead to hefty penalties. We're talking fines up to R10 million, or imprisonment for up to 10 years, or potentially both. Even just failing to submit required reports on time can incur daily penalties.
Wow, serious stuff.
It shows how seriously breaches are taken. And in really extreme situations, if a provider is failing badly and putting clients at risk, the authority even has the power to apply to court to put the provider into business rescue, or even apply for their liquidation or sequestration, all in the interest of protecting clients and the stability of the industry.
That's a lot of power. But it sounds necessary given what's at stake. Now, you mentioned earlier that laws aren't static, especially in finance. FAIS has been amended quite a few times. How does it fit in with the newer, broader Financial Sector Regulation Act of 2017? What does that relationship mean for how FAIS works today?
That's a really important development for understanding the current landscape. The FSR Act, the Financial Sector Regulation Act of 2017, established a more unified Twin Peaks model of regulation in South Africa. FAIS is now very much integrated into this broader framework.
What does integration mean in practice?
Well, for starters, many references in the FAIS Act that used to talk about the registrar or the Financial Services Board now effectively refer to the authority, which is the Financial Sector Conduct Authority, or FSCA, one of the Twin Peaks. This harmonizes terminology and ensures FAIS operates consistently within the overall structure.
So it's part of a bigger regulatory machine now.
Exactly. And many procedural aspects, things like how fees are determined, how inspections are conducted, even how decisions are appealed, are now governed more directly by the FSR Act's provisions. For example, if you disagree with a decision made by the authority under FAIS, you don't appeal in the old sense, you apply for a reconsideration by the tribunal, a specialist tribunal set up under the FSR Act.
So the processes are more standardized across the financial sector.
Yes, it reflects a move towards a more unified, consistent, and hopefully more robust regulatory architecture for the entire financial industry. And the fact that FAIS has been amended numerous times since 2008 just shows it's a living piece of legislation. It's constantly being tweaked and updated to address new market realities, new products, new risks, all aimed at improving client protection within this evolving framework.
It sounds like it's designed to keep up.
It has to. But amidst all this detailed regulation, there's one final point in the Act that's really crucial for consumers to know.
What's that?
The Act explicitly states that nothing in it takes away a client's existing rights to seek legal redress through the courts under common law or any other relevant statute.
So FAIS adds protections. It doesn't replace your basic legal rights.
Precisely. Your fundamental rights aren't diminished. They're actually enhanced by the specific protections and avenues like the ombud that FAIS provides. It gives you more tools, not fewer.
We've certainly covered a lot of ground today, from figuring out what a financial product even is to understanding the ombud's role and those really important fit and proper standards that are meant to protect all of us. This deep dive into the FAIS Act, well, it really shows the amount of effort that's gone into trying to safeguard financial consumers in South Africa.
It's a complex but essential framework.
Ultimately, I think what this all means for you, the listener, is that the financial advice and services you get aren't just happening in a vacuum. They're subject to this robust, evolving system that demands integrity and accountability. It really is a cornerstone of trust in the financial industry.
Indeed it is. And if you step back and look at the bigger picture, the FAIS Act, particularly now it's integrated with the FSR Act, strikes a crucial balance. It aims to foster a healthy, dynamic financial services sector while at the same time providing clear rules, professional standards, and accessible ways to resolve problems when they arise. It really underpins the idea that a trustworthy financial market relies on informed consumers and transparent conduct from providers.
That's a great summary.
But, it also raises a forward-looking question. Given how quickly financial products and services are evolving, think about robo-advice, AI-driven financial planning, new digital platforms, what new forms of advice or intermediary service might pop up in the near future, and how will they challenge or perhaps even expand the scope of what this comprehensive act needs to cover next?
That's a really fascinating thought to leave us with. Where does regulation go next? Thank you for joining us on this deep dive into the FAI Act. We really hope this exploration has empowered you with some useful knowledge, whether you're making your next financial move or maybe even studying law. Until next time, stay curious.